may proceed.
Good afternoon. My name is Mark Chumley, representing Cintas Corporation, the appellant in the first matter. If I could, I'd like to reserve 4 minutes for rebuttal. Thank you. May it please the Court, this is an appeal from a denial of a motion to compel arbitration that was filed by the defendant below, Cintas Corporation. The relevant facts are not in much dispute and are represented in the record. The appellee, Mr. Schwalier, was hired by Cintas Corporation in May of 1998, signed an employment agreement which contained a broad clause agreeing to arbitrate any disputes that arose from the employment relationship, and then when his employment ended in January of 2000, subsequently filed this lawsuit without ever making any effort to arbitrate his claims. Cintas Corporation filed a motion to compel arbitration in the court below. The motion was denied without explanation by the trial court in August of last year, and this appeal follows. Very briefly, the test that should have been applied in evaluating Cintas's motion to compel arbitration is a three-part test, and it is 1, whether an agreement to arbitrate exists, 2, whether the issue to be submitted to arbitration is in fact arbitrable, and 3, whether the right to arbitrate was somehow waived. The record shows that the only issue in this case is with respect to the first part of the test, whether an agreement to arbitrate exists. The record also demonstrates quite clearly that there was an agreement to arbitrate. The employment agreement that was executed by Mr. Schwalier includes a clear agreement that broadly states that he will arbitrate any and all claims, disputes, or differences arising from the employment relationship. Those are exactly the claims that have been asserted in this matter. And really, with respect to the trial court's analysis, that properly should have ended the analysis with respect to the first prong of the test. The analysis is simply whether or not the agreement to arbitrate exists, and in this case it plainly does. And the plaintiff below and even in this court has never attacked any aspect of the arbitration provision itself. The arguments that the plaintiff appellee has made implicate the separability doctrine as it relates to arbitration. And that doctrine holds that a challenge to arbitration must be directed specifically to the arbitration clause, not simply to the agreement within which the clause is contained. The issue is whether there's a valid agreement to arbitrate, not whether a valid agreement containing an arbitration provision exists. The court's role...
If there was no consideration, as the appellee contends, then there wouldn't be a valid agreement. Is that correct?
The issue of whether or not there's consideration could be used, a failure of consideration could be used to attack a contract as a whole, but in this case none of those arguments would apply with respect to the arbitration provision separately. And that's the issue. An argument broadly against a contract, as has been made in this case, may have some bearing on whether or not an entire contract is enforceable. But if that contract contains a valid arbitration provision, that ends the court's analysis. Any further analysis regarding the contract, any claims relating to the contract, and so forth, are properly put before an arbitrator. That's the essence of the separability doctrine as it's been defined by state and federal law.
Well, I'm missing something there, though. Maybe you can help me out with it. But if the entire contract is invalid, let's say it's one that's against public policy or that it's not supported by consideration or any number of reasons that might make a contract invalid, then I assume the arbitration clause would be of no force and effect at all, would it?
Well, there are instances when a contract might be held to be invalid and there would be no contract per se, but the scope of the test and what the court is supposed to be looking at is whether or not there is an arbitration agreement, an agreement to arbitrate claims. And if there is, that really ends the analysis. And there may well be other problems with the contract, other issues that the parties may litigate, but those need to be litigated in the arbitral forum. So, yes, it's true that a failure of consideration or any number of other contract theories could be asserted by a party, But if there is a clause, a valid clause to arbitrate, then an arbitrator is the individual who should decide those claims. They should not be decided in a court.
You mean to say that if a contract was otherwise subject to revocation or rescission, that so long as the contract contained an arbitration clause, that trumped whatever other deficiency that the contract may have?
I wouldn't say that it would trump a deficiency in a contract as a whole. The issue with the arbitration is in what forum should the dispute be heard. The fact that a contract claim or for example, a rescission claim may exist is separate from what forum that claim should be decided in. And in the instance of a valid arbitration clause, that decision needs to be made by an arbitrator in an arbitral forum. It doesn't have any bearing on the substantive claims that a party might have. The issue is really who is to decide what the outcome of the substantive claims would be. And there are means, of course, to challenge an arbitration provision specifically, and those are relevant, as courts have held. The separability doctrine, again, holds that a challenge directly to that arbitration clause may well be sufficient to defeat the right to arbitrate, but that's not what we have in this case. What we have in this case is an attack on the contract as a whole, and that is simply insufficient under that doctrine to defeat the right to arbitrate.
Well, it sounds like what you're saying is even if the contract as a whole is invalid, that somehow the arbitration clause lives and it can force the people to go to arbitration?
In essence, yes. I mean, if the challenge is to the entire agreement, if the court determines that there's a valid arbitration agreement that is enforceable under state law, for example, is not unconscionable, is not unnecessarily unfair to one of the parties, or gives one of the...
When you're reading from those cases that say that part of this test is to determine whether there's a valid arbitration agreement, aren't the courts speaking more broadly to the question of whether or not the contract that contains the arbitration agreement is valid? I mean, you can't have a valid provision in an invalid contract, can you?
That's really not the essence of what courts, the Prima Paint case decided by the United States Supreme Court. And
well, isn't your better argument in this case that the contract is not invalid?
Well, of course, that's our position. The contract is not invalid, and the only attack that has been made on the validity of the contract is a failure of consideration. And that fails on two counts. I mean, first of all, the attack on the failure of consideration, I concede that a lack of consideration can undermine the enforceability of a contract, but that's really not what is going on here. The claim that the plaintiff made to the trial court was not that there was no consideration supporting the agreement, but that he was not paid all of the consideration that he was entitled to receive under the agreement. And those are two vastly different things. In the one case, an agreement would be illusory because it would be without consideration. A failure to be paid all of the consideration one is entitled to, however, is simply a breach of contract claim that plainly is properly decided by an arbitrator. The contract in this case, the employment agreement, the consideration that is specifically provided is continued employment and an increase in compensation benefits or responsibilities. Now, there can be no dispute that after the plaintiff signed that agreement, he continued his employment for over 6 months. The issue that he has raised is an argument that he was not paid the additional consideration he was entitled to. This is simply a breach of contract claim. It's not a failure of consideration claim, and there's no real dispute that the contract itself does not provide for consideration. It does. The argument is he didn't get paid all of the things that he was entitled to receive, and that is plainly simply a breach claim that should routinely be decided by an arbitrator.
Why didn't the company pay him?
Well, the company's position is that he was paid.
The additional amount?
Yes, and I don't know that that sort of factual dispute has any bearing.
I don't mean to get into that.
That's a disputed fact. We did not go into that in any great detail because we did not think that that factual issue is relevant to what should be decided here. But the fact is it is disputed, and our position is should properly be decided by an arbitrator. And there's no evidence that an arbitrator would not be able to properly decide just that sort of a dispute. On the other hand, if you accept the plaintiff's argument that a breach of contract means that the arbitration provision is unenforceable, no breach of contract claim could ever be submitted to arbitration. And plainly, that's a ridiculous result that would not be appropriate under Florida law or under federal law. The other problems that we have pointed to in our brief, we stand by with respect to the trial court's denial of the motion without explanation. Even this issue of whether or not there was consideration was improperly brought before the trial court. There is no admissible evidence relating to that issue. All that was presented to the trial court is the argument of counsel. There is no admissible evidence that Mr. Schwalier was denied all of the consideration he was entitled to. And on a broader level, to deny a motion to compel arbitration when there plainly is an agreement to arbitrate within an employment agreement with no explanation and on the record that was before the court is not only improper under well-settled law, it also runs counter to the strong policy of both federal and state law that strongly favors arbitration of these sorts of claims. And for all of those reasons, it's our position that the trial court's order denying the motion to compel arbitration should be overturned. Thank you.
May it please the court, counsel. My name is John Unsicker and I represent Russell Schwalier. This case began when Russell Schwalier was fired because he made a workers' compensation claim. We're here today because the trial court denied a motion to dismiss as well as an alternative motion to compel arbitration. It should be viewed in the context of a motion to dismiss when the court considers the argument of counsel that was made during the matter below. It's unknown what the basis for the decision by the trial court was. For all we know, the decision was based on something that was said by the defendant in the case and not the plaintiff. The agreement that is at issue today states that the consideration would be continued employment and an increase in pay, increase in responsibilities, increase in benefits. These increases naturally assume a continuation of employment. So what we're faced with here is consideration in the form of increased pay, increased responsibility, or increased benefits.
So, counsel, we don't have a complete failure of consideration in this case, do we?
Your Honor, if the complete failure is the continued employment and the increase in pay, then there was a continuation of employment. That part is granted. But the recitation of consideration was continued employment and a pay raise. In exchange for you sign this document, we give you a pay raise, which naturally assumes a continuation of employment. Mr. Schwalier signs the agreement, no pay raise is given. That fact is alleged in the complaint. This is a motion to dismiss. Those allegations should be assumed to be true if they're fairly pleaded.
Let me go back to a comment that you made a little bit earlier regarding we don't know why Judge Nobles, or rather she stated no reasons in her order for denying the motion to dismiss or stay proceedings pending arbitration. I understand that the hearing that was conducted was not transcribed. You're not suggesting, are you, that there were factual or evidentiary matters presented to Judge Nobles that may in some way have influenced her decision? And of course we don't have a record of that particular proceeding. If I understand correctly, simply arguments of counsel as a matter of law were presented to the trial court.
Well,
You're not suggesting the contrary, are you?
There was an affidavit that was presented by the defense that included a copy of the agreement. And
we have that, yes. We have
yes,
that
sir.
in the record, but there was no testimony offered at the
correct, Your
hearing.
Honor. There was no testimony.
So you're not suggesting that because there were evidentiary matters which were not made part of the record that we have no choice other than to affirm the ruling of the trial court?
No, sir. I'm not making that assertion or representation to the court. The question about the separability clause should be addressed. The cases that Cintas cites all dealt with fraud in the inducement, those being the post-tensioned engineering corp, the coastal Unilube, I believe. No, I'm sorry, that was the Prima Paint case. And the other cases that were cited subsequently all dealt with fraud in the inducement, as opposed to a case where there is an alleged failure or lack of consideration. In those cases, the question about fraud in the inducement of the contract went to the contract as a whole. In our case, the lack of consideration would affect each and every clause of the contract or the agreement, including the provision on arbitration. If you separate out everything else and just have the arbitration clause left, and the rest of it fails for lack of consideration, then there is nothing to arbitrate. There is no agreement. It would be a waste of time to try to arbitrate something that doesn't exist because it's not enforceable due to a lack of consideration.
Well, could your client file a suit against Cintas? He filed a retaliatory discharge claim, but could he file a suit for breach of contract, claiming that he was improperly discharged because he has a continued right to employment, and that the company breached its agreement by not paying him the additional salary?
In fact, Your Honor, the complaint includes an allegation of unpaid wages. And yes, sir, I believe that that's permissible under the facts of this case.
Well, you're relying on the contract for that claim. You contend for the purpose of that claim that the contract is valid.
No, sir.
Or do you not?
No, sir, I do not. At a point sometime after he executed the agreement, he was placed in a different position within the company and was promised an increased pay at that time. This was several months after he had executed the agreement, and he did not receive the additional pay to which we believe he was entitled, and that's the basis for the unpaid wages claim.
Well, why wouldn't that be a proper arbitrable claim?
If there were an enforceable agreement to arbitrate, Your Honor,
But if there's no enforceable agreement, then he's not entitled to the additional pay they promised to give him. Is that right? I mean,
no, sir. There's a statute in Florida right on point that says if you work and don't get paid the value of your services, then you have a right to.
Well, yeah, he may have a right to collect that money under other, but as a breach of contract matter, I mean, the contract's either valid, in which case they have a better argument for arbitration, or it's invalid, in which case you have no claim for additional pay. At least no claim under the contract. Do you agree with that?
I agree with that,
Okay.
Your Honor. The claim for unpaid wages was based on the Florida statute.
Let me ask you a question. Did your client have any employment expectation before this contract was entered? In other words, did he have any expectation of continued employment? Like, for example, did he have a previous contract?
There was no previous contract, and he didn't have any greater expectation than any of the rest of us.
He was an at-will employee?
Yes, sir.
Okay.
Yes, sir. And I submit to the court that he continued to be that after the agreement was signed. With regard to the issue of burden of proof, I believe I've already stated to the court that we were before the trial court on defendant's motion to dismiss, and that motion was denied. The allegations in the complaint ought to be accepted as true, and those allegations in the complaint alleged sufficient facts for the court to make its decision. Mr. Schwalier was told to sign the agreement and he would receive a pay raise in exchange for that. He signed and got no raise. According to the specific language in the agreement, There was no consideration for his having executed the document. There was a failure of consideration which rendered the contract unenforceable. Therefore, Mr. Schwalier ought to be able to bring his claim in state court.
Well, the unpaid wages, it seems to me, the claim is for back damages for back pay, bonuses and benefits associated with employment, etc. Doesn't that relate to the contractual terms, that particular claim?
The lost wages or unpaid wages claim?
Count 3, unpaid wages, which you have asserted.
No, sir. There's no relationship between his having signed the agreement in June of 1999 and his having been changed to a different job within Cintas in September of 1999.
The allegation is that Cintas wrongfully failed to pay all wages and commissions due to your client during the period that he served as a catalog sales representative. You saying that doesn't include the contractual term as well?
I don't believe so, Your Honor.
It's entirely independent, and it's entirely based upon the statutory remedy of retaliatory discharge.
Yes, sir.
All right.
Thank you, Your Honors.
Just wanted to readdress or revisit briefly one point that was made there, which is that there appears to be no disagreement here that at least part of the consideration that was called for in the agreement was paid, and that at least is continued employment, which is recognized under Florida law as valid consideration. So we have,
assuming he didn't previously have a right to continued employment.
and
I guess he didn't.
I believe we're in agreement that he was and remained an at-will employee, and therefore the ongoing relationship is in itself consideration. So really there is no colorable argument here that this agreement could fail for a complete lack of consideration. The issue is, did he or did he not get everything he was entitled to? That may well be an issue that may or may not have merit to be decided, but it needs to be decided by an arbitrator. There is no colorable basis for argument.
Can Mr. Schwalier sue under the contract for improper discharge and for failure to pay the additional money?
Discharge, I would say no, because he was plainly an at-will employee. I don't think he has a contractual...
No. After he had the contract, he had you have the contract gives him a continued right of employment.
Well, as to the claim that he was entitled to, for example, an increase...
Let me just ask you something, because if you're going to tell me that after the contract he has no right to sue for discharge, that seems to go against your argument that he had a continued right to employment under the contract. I mean, either he did or he didn't.
I think he had a right to continue his at-will employment and to continue that employment
Are you
at a
saying
higher
that this
rate.
provision was the equivalent of an at-will employment?
I believe that the provision, the quid pro quo for him signing this agreement was continued at-will employment. And I believe that theoretically, anyway, he could pursue some sort of a claim.
And you think continued at-will employment is consideration?
I believe it is.
What on earth did he get by continued at-will employment that he didn't previously have by at-will employment?
Well,
what was new that he got in return for the promise he made to you?
I think that the typical way at-will employment law is addressed under the law is that every day is a new day under at-will employment. He continued his employment for well over 6 months.
But if he had no continued employment rights because he was just continuing on as an at-will employee, what new consideration did he get?
Well, according to the agreement, he also got an increase in compensation, benefits, or responsibilities. Now, obviously, that point is disputed, but he continued his employment our position would be and will be before the arbitrator at a higher compensation or at some other one of those pieces of consideration called for in the agreement, and I think that's subject to some amount of argument. But there wasn't just the continued at-will employment. There were also these other components, and I think it's disputed whether or not he received these things.
I'm having trouble understanding what continued at-will employment is. It seems like nothing to me. It seems like you're an at-will employee, which means you can get fired because the boss doesn't like the color of your hair or the way you smile. Continued at-will employment, what does that add to protect the employee? Because it seems to me it has to add something for it to be consideration. If it's just a continuation of the same thing, then what was the consideration?
Well, initially, as I said, it wasn't the only piece of consideration called for in the agreement, and I would agree that it would be troubling if his employment had ended perhaps the following day, the following week, or the following month, but he remained employed for over 6 months after signing this agreement. Was that a situation where he had an unfettered right to continue that employment? I don't think so, but I think he did receive a benefit for signing this, and it wasn't just the additional consideration of compensation benefits and so forth.
You're saying that the allegation that Schwalier made that in his complaint that he received a change in work assignment which resulted in a reduction in pay was a matter of dispute.
That issue is going...
It's a factual matter of dispute. And you're also saying that whether or not the employer complied with its contractual obligation to increase the employee's rate of compensation was also a factual issue?
Yes, I think those are disputed issues that are properly decided by an arbitrator, but if in fact he did not receive the increase that was called for by the agreement, it seems to me that he would have a claim before the arbitrator for that sort of a failure.
All right.
Thank you.
Thank you. At this time, we're going to take a